which is where we will be focusing on how your workplace can legally and effectively navigate disability and leave issues during a pandemic. My name is Gary Eidelman, and I'm honored and proud to be the chair of the firm's labor and employment law practice. I'm also pleased to be serving as your moderator for today. I first want to give you a brief overview about what we're going to be doing today. From now until about 12 o'clock, we'll have our substantive presentations that are going to be led by 6 of my colleagues. Shortly after noon, we'll take a break and return back at around 12:15. And at that time, you'll be assigned to one of our breakout sessions that we're calling our WISE, W-I-S-E forums, with WISE, of course, standing for Workplace Initiatives and Strategies for Employers, which just happens to be the name of the Saul Ewing Labor and Employment blog. During this time, we'll gather in smaller groups together to talk informally about the challenges that you are facing given these extraordinary times. Each of the WISE forums will be facilitated by members of our labor and employment practice. So during the next couple of hours, as you're listening to the presentations, we ask you to think about one workplace problem or an employee issue that's really keeping you up at night so that we can discuss it during this informal time, during the WISE seminars. A couple of housekeeping measures before we get to our program. Number one is we are using the Zoom meeting platform today because we're going to be going into those other breakout sessions afterwards. And so everyone will be muted until we move into those WISE forums at 12:15. You should also not feel obligated, as many of you are today, to display your video during that time. It's absolutely fine. Nobody's judging. We see all your names. And at 12:15, you'll receive an invitation to join your WISE forum. You'll be unmuted at that point in time, and we hope you'll also be unmasked so we can see you. Also, during the substantive programs, we'll be using a PowerPoint presentation. So to see who the speaker from Saul Ewing is, you might want to go from gallery view to speaker view, whose remarks will be tied in to the PowerPoint content. Because we have more than 200 attendees today, questions can be submitted to our presenters via the chat feature at the bottom of your screen. We will do our best to answer all questions within the time allotted. And you'll also have a chance to raise questions during the WISE forums. Given the subject matter, we do anticipate a lot of questions, so please utilize the chat feature for those questions only. Today's program has been approved for continuing legal education credit in Pennsylvania, New Jersey, Delaware, Illinois, and Florida, and we have an application pending in Minnesota. We've also been approved for SHRM recertification credits and have an application pending with HRCI for recertification credits. We expect to hear from HRCI within the next 2 weeks. In order to verify your participation and receive your appropriate certificate of attendance, you'll need to complete a brief accreditation survey and note the random numeric codes that we will provide during the webinar. These aren't subliminal messages, they're random codes that you just have to be aware of. There will be 3 of them. The survey link was in your reminder email, and we posted the link in the chat box as well for your convenience. Please be sure to complete the survey within the next 5 days. We'll also follow up today's program with a thank you email that will include a PowerPoint or a PDF of today's PowerPoint, the accreditation survey, and any relevant materials that you may have. Now, of course, during a pandemic, you always have to have a giveaway, and you have to have something like that. So when you were logged in today, you were asked for your mailing address, and we only asked it because we'll be sending our participants a gift via email. So be on the lookout for a sweet treat. This isn't the kind of thing you want sitting in your office for a couple of months. So if you need to give us an updated mailing address, just let Mary Brightman know it's Saul Ewing, and something will be arriving in the next couple of weeks. Of course, because we're lawyers, there's got to be a legal disclaimer. The provision and receipt of the information in this presentation is not legal advice, does not constitute a lawyer-client relationship, and should not be acted on without seeking professional counsel who've been informed of the specific facts, and we're happy to do that with you after today's program. So we're ready to get started. It really gives me great pleasure to allow me to now introduce our panelists and topics for the next couple of hours. Kicking us off is, and by the way, these are all my dear friends and colleagues besides just being lawyers in our firm. My dear colleagues and lawyers, Dina Kalo, who's the vice chair of our group and partner in Philadelphia. She's being joined by Lisa Koblin, also an associate resident in our Philadelphia office, and Lauren Schoberl, who is an associate in our Minneapolis office. And they're going to be discussing the FMLA, the ADA, and COVID implications relating to those laws. We're then going to move right into a discussion on litigation trends during COVID. Yes, that bad word, litigation, but we want to talk to you about those things. And that's going to be led by Ruth Rawls, partner in our Princeton office, Anna Marie Tejada, a partner in our Newark, New Jersey office, and last but not least, Jillian Cooper, an associate resident in our Philadelphia office. And with that, I'm going to zoom out, and let me turn it over to Dina, who's going to zoom in.
So hello, everybody. I'm going to share my screen and get us started. There we go. So employee leave and common issues during the COVID-19 pandemic. So in preparation for this seminar, we have had a lot of questions about whether this was going to be all about the FFCRA or how we were going to approach it. And one of the things that we decided was we certainly are going to talk about the FFCRA, but we really want to hit on topics that were relevant to everybody attending the seminar. And we know that, FFCRA may or may not be ending at the end of the year. So we will spend a little bit of time at the beginning of this seminar talking about the FFCRA. And the way we approached this was with a lot of hypotheticals, because we think, and we've gotten a lot of feedback in past seminars, that the practical approach is always best. So we are going to try to give you some practical examples and solutions to those to help you apply them to your practice and your workplace. So we're going to start with the FFCRA, but then we're going to jump into pre-COVID, right? What were we always dealing with, FMLA, ADA, and how are we integrating COVID into those pre-COVID ideas? We certainly are now also dealing with state and local sick leave laws and COVID laws. How are we integrating those? We're going to spend some time on common issues and then best practices as we wrap it up. So COVID leave, employee leave in the COVID-19 era. So the Families First Coronavirus Relief Act, FFCRA, I think everybody's heard of it, has been dealing with it, but there are two types of leave that we are managing, and I'm sure everybody's had to deal with at least to some degree up to now, if you are a qualified employer. So who is qualified? Those employers with less than 500 employees. And FFCRA provides two types of leave in response to the pandemic: emergency paid leave and expanded FMLA. And I think that's really been a challenge for employers. And we're going to talk about a hypothetical that deals with, what happens when we have someone who's taken FMLA already and now has COVID, or has issues related to COVID, or their child's school is closed. How do we deal with that? But to talk about a little bit on emergency paid sick leave, what are the conditions that qualify an individual? We have given and will give out as part of this packet of materials that you'll get after the presentation, the notice that needs to be hung in every workplace, the employee rights notice that the DOL is giving out. And it lists the 6 requirements to be eligible for these leaves. Certainly, if you have a local order, federal, state quarantine isolation order, that's going to qualify the individual if they're covered by it. If you've been advised by a healthcare provider to quarantine, if you're experiencing COVID symptoms and are seeking a medical diagnosis, If you're caring for an individual, and again, it's not a family member, an individual, could be a roommate, subject to the orders. Caring for a child whose school or place of care is closed, which as we've gone through the COVID crisis, many of the schools have now been reopened, and that's been an interesting scenario. We'll talk about that as we go through this a bit. And then the sixth one, which really has never been truly explained, which is experiencing any other substantially similar condition. I don't really know what that is, but ultimately, COVID-related conditions have been have made the individual eligible. So for emergency paid sick leave, it's those first 10 days. For the first three categories, for the individual's own condition, they get their full pay up to $500 a day for 2 weeks. For the caring for somebody else or for their child's school being closed, it is 2/3 of their pay up to $200 a day. And there are tax credits that you can get if you get the proper documentation. So that's the FFCRA in a nutshell. So our first hypothetical deals with Tricky Trisha. And one of the things that I want to emphasize with Tricky Trisha is that what we see in this, we see in a lot of situations, which here you have an employee who has a history of attendance problems and unexcused absences. And one of the things I want to emphasize here is we cannot use those prior issues if in fact Tricky Trisha is calling out of work now because she has a fever and she has a cough and she says that she's going to see her doctor for a COVID-19 test, but can't get an appointment for 3 days. So even though she has a history of attendance problems and unexcused absences for failing to come to work, and what do we do? How do we handle her time off? The frustrated employer would say, hey, this sounds like she is abusing the system. And as someone who has abused the system in the past, your inclination may be, we want to just discipline her or terminate her because this is the 5th time in the last 6 months that she is taking an unexcused absence. The problem that we have is if Trisha is seeking to go to the doctor, what can we require? If you have less than 500 employees, you're covered by the FFCRA. Trisha is likely to be entitled to emergency paid sick leave under the federal law. We are going with what she is saying to us right now. She has symptoms of COVID-19. She's seeking a medical diagnosis, and that is protected. So what can we do? We can require that she provide us the doctor's note when she gets it in 3 days that she saw the doctor, she got the COVID test, and then certainly we have to wait for the results. We certainly have had issues where an employee has said they are going to get a COVID test. We asked for the doctor's note, we never get it. That is a different situation, but here taking Trisha at her word, she's going to get that diagnosis, she's going to get the test, and therefore she is covered by the FFCRA, at least until we know what is happening with Trisha. We cannot use this request off to start enforcing discipline for her past violations or even potentially this violation until we know that either she's not seeing the doctor or she's lying to us, which we're not going to know until she actually goes to the doctor. If she doesn't go, then we know. And I'm going to hand it off to my colleague, Lisa Goldblum.
Good morning, everyone. So we're going to switch gears a little bit now and talk about the expanded FMLA. So first we were talking about the emergency paid sick leave, and now we're talking about EFMLA. Again, this is under the FFCRA, but we want to touch base on this because we've had a lot of questions about this subject. In this case, George took 3 weeks of regular FMLA back in January to recover from surgery. Now he wants 12 weeks of expanded FMLA leave because his child's school is closed and he needs to be home with his child. So the question here is he entitled to 12 weeks of expanded FMLA? The answer is no. An employee who is eligible receives a total of 12 weeks of FMLA and EFMLA combined in a 12-month period. So in this case, because he already took 3 weeks within the last 12 months, he only has 9 possible weeks remaining of expanded FMLA leave or regular FMLA leave. So whether he was requesting leave for something covered by the FFCRA or something covered under regular FMLA, he only has 9 weeks remaining. So it's important, as we go through this presentation and as you're dealing with questions and concerns from employees, to keep in mind how all of these laws interact with one another.
The only thing I want to jump in on there is you also have to remember to follow your policies. So the calculation of how you count your leave year is also important, right? We want to make sure that, how did you count your leave year? Where did you go by? So just make sure you're counting the leave year correctly, even with the EFMLA.
Correct. Okay, next slide. All right, so here's another EFMLA hypo. In this case, we have an employee, Maria, who says to you that she needs a few weeks off of work to care for her 8-year-old son because he's doing virtual learning. I'm sure everybody is experiencing, whether in their own personal lives or with employees, all sorts of fun virtual and in-person learning combinations with, every school district has its own plan, right? So Maria says she needs some time off and you say, okay, is the school closed? Can you provide us some documentation or information about the school? And Maria says, well, technically the school is open, but I've decided that I want my son to do virtual learning because I think it's safer. And a lot of school districts have an option for parents who want to keep their kids home, right? So the question here is, would she be covered by expanded FMLA leave? Now, in this case, she probably is not covered, and that's because the question here is whether school or daycare, if it were a younger child, is unavailable due to COVID-19. In this case, the school is actually open and available, but she's choosing not to utilize it. So even though it might be a safety concern or, a best practice for her personally not to send her son into school, the school is actually available. And so this leave probably would not be covered under expanded family medical leave. However, you should keep in mind that if Maria is keeping her son home because he has a disability or a serious health condition and his doctor is saying he cannot go to school and she has to care for him, well, then we have to consider whether she might be eligible for regular FMLA, right? So there's no one size fits all, and these are very fact-specific situations, but this is why it's really important when the employees come to you to engage in this back and forth, right? And talk to them about, well, what's really going on? What's the reason for their request? And, in this case, why is her son being kept home? So if it's just personal preference, not covered, not protected, and you would have to determine at that point, what are your policies with other similarly situated employees, right? So if you had another employee who similarly requested to either work from home or take time off to be with their child, and they're in a position similar to Maria, you're going to want to be consistent with your responses. Otherwise, that's where we have those issues about disparate treatment, right? So if you told a male employee that he could stay home with his child, but you're telling Maria no, well, why? Why is there a difference in that decision? And all of that should really be documented or be consistent with a written policy that you have in place. Next slide. Great. Okay, so as we mentioned, we're going to talk about leaves that were in place before the FFCRA and are continuing now. But before we get into that, you'll see here there's an accreditation code on your screen. It is 908451. One more time, it is 908451. So if you are seeking CLE, SHRM, or HRCI credit, please take note of this code. You will need it after the presentation as part of a survey in order to get credit for this course. Okay. As a fun little refresher, let's just walk through FMLA quickly. We're anticipating that most of you, if you have at least 50 employees, are familiar with the FMLA. If you are a smaller employer or you're expanding and you're at about that 50 employee threshold, it's really critical to pay attention to the FMLA, make sure that you get a policy in place and that you're providing leave to anybody who becomes eligible. But as a reminder, as I said, it applies to employers who have 50 or more employees within a 75-mile radius, who've been working at least 20 weeks in the calendar year. Eligible employees will receive 12 weeks of unpaid leave in a 12-month period if the employee has worked for you for at least 12 months and has worked at least 1,250 hours within that 12-month period. So brand new employees are not entitled to FMLA, but if they've been with you about a year, chances are they're covered. Okay, so when we talk about FMLA and why someone might be entitled to this leave, there's three major categories in which someone could be eligible. If they're suffering from a serious health condition, to care for a child, spouse, or parent suffering from a serious health condition, or because they're because of childbirth or they're bonding with a new child, whether it's adoption, foster care, et cetera. Serious health condition is the critical term here, right? So when we talk about serious health condition, we mean something that requires overnight or inpatient care or an absence from regular daily activities for at least 3 days and continuing treatment. So a serious health condition is not the common cold or flu. It is not when you stub your toe, things like that. It really requires ongoing care. It is fairly broad, but it's important to know that it's not necessarily everything. Just because an employee doesn't feel well, maybe they get a stomach bug, they're not necessarily going to be eligible for FMLA. This is really for more debilitating conditions. And then I do just want to quickly note that for anybody dealing with FMLA leaves, the DOL, the Department of Labor website, has the template forms that you should be using to process employee requests for FMLA, right? You don't have to use their exact form, but we find them to be the most helpful. And there are forms that you need to give out at certain points during the FMLA process. So it's really critical that you follow those steps. So one question that we have been faced with recently is whether COVID-19 is a, quote, serious health condition. So most people who are infected with COVID-19 have those cold and flu-like symptoms, right? The sore throat, the cough, fever, things of that nature, and it's usually fairly temporary. Those symptoms, if you think about our test, really would not qualify for a serious health condition. However, unfortunately, a lot of people experience complications from the virus, or it leads to a more serious health condition. So it could be covered by the FMLA, depending on what they're diagnosed with by a medical professional.
So another pre-pandemic law under which employees can seek leave is the Americans with Disabilities Act, or the ADA. This one is likely familiar to most or all of you. So just a brief refresher, under the ADA, covered employers are those private employers with 15 or more employees and certain state and local government entities. Keep in mind that leave under the ADA is applicable if an employee has otherwise exhausted all other forms of leave under an employee benefit program or law. So the mechanism by which someone could seek leave under the ADA is through a reasonable accommodation request. And as a refresher in that respect, an employer is required if an employee with a disability seeks a reasonable accommodation to allow them to perform their primary job duties, the employer must grant it, provided that that accommodation doesn't cause undue hardship. So in other words, is reasonable. So as I mentioned, a reasonable accommodation could include, if all the stars align, unpaid leave. As you all may be familiar, the definition of disability under the ADA is very broad. It's very fact and circumstance dependent, but in general, under the law, it means a physical or mental impairment that substantially limits one or more major life activities. And a person who is disabled is one that has a record of such impairment or is regarded as having such an impairment. So a disability could include problems with cognition, mental health issues, sight, vision. It's like I mentioned, very fact and circumstance dependent. Keep in mind that pregnancy is not a disability under the ADA, but certain pregnancy-related conditions could be. So the question of the day is COVID-19 a disability under the ADA or equivalent state laws? And the answer is kind of. So COVID-19, the virus itself, is not a disability, but it could lead to a disability, or it could pose a safety concern for employees who are especially vulnerable or immunocompromised. So remember that you cannot have a bright line rule that yes or no, any reasonable accommodation request related to COVID-19 would be granted or denied. Remember that there's the interactive process that the employer is entitled to engage in. So the interactive process is the process by which you find out more information from the employee about their condition and how their requested accommodation, in this case leave, relates to their ability to do their work or to their condition. And you should also bear in mind that employees are entitled to accommodations only for their own disability. So what I mean by that is, let's say an employee cares for an immunocompromised child or an elderly family member who lives with them, and they request leave because they're worried about exposure in the workplace to COVID-19. So in that circumstance, the disability that they're claiming does not belong to them. It belongs to the family member. So in that case, they're not entitled to an accommodation.
So remember here, we're talking about ADA. If we go back to FMLA, right, that individual may be and likely would be entitled to FMLA leave if a family member or a child has a serious health condition, right? So that's why when we talk about the intersection of all these laws, it's important to think about what they're asking for, what it may fall under, and what they would be entitled to. So if they come to you and they say, okay, so I have, my mom who I live with has been exposed, is ill, and I need to care for her. If you're qualified under the FFCRA, we're going to have FFCRA benefits. You may have regular FMLA benefits, whether or not you're qualified under the FFCRA. And then, as Lauren's describing it, the question of whether after all those benefits run out, certainly there is no ADA rights. However, you may have your own personal leave policies in your company that may apply. So there are all these different rules that you have to start looking at when, in fact, these issues come up.
Thanks, Tina. So aside from reasonable accommodation requests, another place where the ADA is implicated in the era of COVID-19 is questions with medical testing and screening of employees. So yes, employers may ask their employees limited questions about COVID-19 symptoms, such as, have you experienced these symptoms of fever, cough, shortness of breath, and then they conduct temperature screenings. However, if an employer does decide to implement some sort of testing or screening regimen, they should do so on an equal opportunity basis, which means they can't target a certain employee or group of employees. Like if they want to test Tricky Trisha because they don't trust that she'll report symptoms, you can't just target Tricky Trisha, for example. Also, all employee information that is gathered in connection with any COVID-19 screening or testing regimen must be kept confidential. There's a few exceptions to that, which I will discuss further, but one of them is when a public health agency requests it. So, as always, even before the pandemic, any employee medical information is confidential under the ADA. So, further exceptions are if a manager who learns that an employee has been diagnosed with COVID-19 or has symptoms, they may share this within the organization with appropriate employer officials. So that could be, let's say that someone in the company has been designated to make decisions about cleaning or quarantining. That person could learn of an employee's symptoms or diagnosis. Also, an employer, for the benefit of the safety of the workplace, they may designate a representative to interview employees
Why is it
who
over
are
here?
who are suspected or confirmed to have the virus through contact tracing.
We're gonna go in 2 minutes. Can you guys go wash your hands? I'll put the book
Just a
away. and wash
reminder,
your
if everyone could please keep yourselves on mute. Thank you so much.
hands. So sorry.
So another hypothetical today, this one involves ailing Avery. So Ava reports to her workplace every day. They're back to work. And she reports to her office manager that she's experiencing symptoms of COVID-19, and she wishes to telework for a few days until she receives the results of a COVID-19 test. So can the office manager tell Avery's coworkers why she's not in the office? And the answer to that is no. The next slide. Yep. The employer may not. That is because, as we've covered, employee medical information, including information about whether they've taken a COVID-19 test, must be kept confidential. But the office manager may tell those, as I mentioned, may tell those with a legitimate business reason to know this information. And they can also tell individuals who've had direct contact with Avery that there's been a suspected or confirmed case of COVID-19 or suspected exposure. So if Avery shares a desk with John, the employer can tell John, hey, we need you to quarantine or monitor your symptoms for a few days. John could deduce that this is related back to Avery, but the employer cannot be the one to say so.
Thank you. So, I mean, if your head's not spinning yet, it will be, right? We have so many different things to take hold of and to try to understand. And so now we have to not forget about the state sick leave laws, right? So states have their own state sick leave laws and now have been implementing COVID laws as well. So the question that you should be asking yourself when somebody requests leave is, number one, and I always try to put it in different buckets. So the way that I try to explain it when I have clients calling me is there's guaranteed leave, right? FMLA gives you a period of guaranteed leave. And then there's paid leave. So what I say is take out a blank calendar and start filling in on the calendar, you know, what the individuals get and for how long of a period of time, so that you can really understand what it is they're entitled to, whether that it's paid and from what bucket it's getting paid from. Many of these leave laws say that the leaves can run concurrently so that we can in fact run, you know, the FFCRA with the state leave laws. There are other laws that say they cannot, that these are buckets that run consecutively so that they can save their New York law, New York paid sick leave to run after. So we just have to make sure that we understand which paid sick leave we're taking the money from. And then certainly if we have PTO available to the employees, can we run PTO at the same time? So federal law doesn't require any paid sick leave, but more and more states and cities are requiring either paid or unpaid sick leave in recent years generally, right? And then COVID on top of it. So we have to be on the lookout for that. This year, the EEOC has also issued guidance on COVID-19 and pandemics. If you haven't taken a look at it, it's really worth it. It's not that long. It's about 10 or 15 pages, and it gives a lot of questions and answers about what employers can do in screening and hiring. It gives some advice on furloughs and layoffs, which the next panel is going to talk about. But it's really worth the time to take a look at it. So with regard to screening, I know Lauren talked about it a little, but employers can screen employees who enter the workplace because an individual with the virus can pose a direct threat. And I do want to talk about screening just a little bit, just from a practical perspective. We have a lot of clients who are doing temperature screenings as employees are walking into the building. And we've talked a lot with the clients about logistics of that. How are we doing it? Some are doing it outside the building, which is great, right? Because then we're not having the exposure issue of lining up inside a building where potentially you're exposed. And then, you know, we have the issue of, if an employee has a temperature and potentially has the virus, they've now exposed everybody else on the line. I had a situation recently where a client called. We had not talked to them before this call, and they said, well, we just had an individual who had a temperature on the line. They screened inside. And I said, okay, so we should tell the other people who were online with that individual for contact tracing purposes of a potential exposure. They had not kept any records of anyone who was on the line with that individual. There was no log, there was nothing. So one thing I would say is if you're going to do these checks, it is important to make a determination of how you're going to log, where you're going to keep those logs, which should be in a confidential medical file, how long you're going to keep them, who's going to do the temperature checks, right? All of these things require a lot of thought, and to ensure that you're doing it in a way that's going to be both confidential and so that, you know, if we do have an exposure issue where it comes up that the person is positive, that we can do what is going to be required of us, which is to be able to notify the individuals who were exposed to that positive test, that they potentially are also exposed. Employers may administer COVID-19 tests themselves. Like you can say, hey, we're going to administer tests, or we're going to send you for a test if doing so is job related and consistent with business necessity. And you can ask all employees in the workplace if they have a diagnosis or symptom of the virus or have recently traveled to a hotspot. Interestingly, though, you know, there's a lot of talk right now about antibody testing. Antibody testing is not considered by the EEOC as a reasonable medical test, and you cannot ask employees to go for antibody testing. The other thing you cannot do is ask employees if their family members have COVID-19 or related symptoms. You cannot ask that on screening forms or on an app that you've developed for your employees. And the reason for that is GINA, the Genetic Information Non-Discrimination Act. However, you can ask if the employee may have come in contact with anyone, not family members, but anyone who has been diagnosed with or has symptoms of the virus. And that way you're not focused on family members and you're getting a full picture of who the individual may be in contact with. Remember, any information you get from employees related to their screenings, to their testing, to their logs, to their temperature checks, whatever it is, must be kept in a separate medical file, right? Just like any other medical information. Just like Lauren said, we must keep this information confidential to the extent we can, or only on a need-to-know basis. Employers may also screen applicants. So we have a lot of questions coming in about, we have applicants coming in, or can we test them or ask them questions? And you can after making a conditional job offer. And this all goes back to because screening is considered medical information. And that's as long as you do so for all new hires in the same type of job. If an employee is just absent from work, you have an employee who's just not showing up, can you ask why? Of course you can. And what if an employee is not screening or is not cooperating with screening? Can you ask them to go home? Can you just send them home? And the answer to that is also yes, you can.
So we also want to touch base on the EEOC guidance and remote workers. A lot of our clients still have a combination of remote and in-person working, or sometimes even fully remote, depending generally on your industry and what area of the country you are in. Or sometimes employees have to work remotely for a period of 14 days or because they traveled, whatever the situation may be. Please be mindful that your anti-harassment policies should still be in effect and still be monitored even when employees are working remotely. So first of all, of course, you want to have a written anti-harassment policy, right? And then we also want to have a email or technology use policy, which clearly says that your anti-harassment policy applies to all communication between employees, whether it's through email, the phone, message on social media, something like that. There should be no medium in which employees are allowed to send harassing or inappropriate messages to other employees that would violate your anti-harassment policy. Your policy should also have a clear complaint reporting process. So if someone has a question or concern, whether they're remote or not, they should know exactly who they can go to with those concerns. Another thing to be mindful of if you're planning to bring employees back to the workplace, or you've done a combination of remote and in-person operations, you can let employees know in advance, hey, by the way, if you have a question about an accommodation due to a disability, please reach out to HR, a manager, whoever it may be, so that you can be on top of these requests, so that you're not in a situation where you're planning to have, let's say, 10 workers in the office or 10,000 workers in the office on a certain day, come to find out a certain percentage of them are not comfortable coming back, or they're not able to come back due to a disability. You do want to try to get ahead of these issues so that you can figure out any logistical concerns that you may have. Next slide. Okay, so once an employee is working remotely and then you're going to bring them back, the basic rule of thumb, according to the EEOC, is that that employee is not automatically entitled to continue working remotely just because they were, right? It's not based on the employee's personal preference or because now they don't have to commute. And don't we all just love sitting in our home offices? It's so great. And even though it might be easier for a lot of people, you, the employer, decide who is working remotely and who is in person. Of course, subject to state and local orders, capacity limits, things of that nature. But the other component is that if an employee comes to you and says, I have a disability and I need to work from home, I'm in a vulnerable population, my doctor says I should work from home, then we have to think about that undue hardship analysis. And an interesting component here is once you've already allowed an employee to work remotely, and assuming the employee has performed satisfactorily in that capacity, employers are in a tricky situation, because now how can you say that allowing that employee to continue working remotely would cause an undue hardship? There absolutely may be situations where an undue hardship does arise, but you have to evaluate this information in these situations as they come up and in light of the circumstances. So if someone is a supervisor that needs to be in touch with their staff, or a faculty member of a school that has to conduct in-person learning, of course there's going to be situations where you need that person physically in the workplace. But there could be a lot of situations where maybe them continuing to work remotely is not really an undue hardship. And that's the type of back and forth interactive process and thought process you need to go through in these circumstances. So now we want to touch on and do some hypos regarding common legal HR issues that my colleagues and I face every day, and that we think a lot of people can relate to. So in the first hypo, Amazing Apartments LLC learns that a new maintenance employee who's only been with them for 2 months was in close contact with a friend who just tested positive for COVID. Yesterday, the maintenance employee worked on an outdoor window repair project with 2 other maintenance workers. The maintenance employee who's telling you this information, he does not have any symptoms, but he said, you know what, I want to take the day off and try to go get one of those tests at CVS. So now you're faced with a few questions, right? You've just learned all this information. How are you going to respond to his request for a day off? And what information, if any, are you going to share with these other maintenance workers? So the important thing here is to understand that when you get these scenarios, it's a multi-step review process. And as Dina mentioned earlier, there's different buckets that you should think of these things in. So here, the first bucket is how to deal with the employee who may have been exposed. The second bucket is how to deal with the other workers who worked with him, right? And how far down the chain do we need to go with our response? So in this case, if Amazing Apartments has less than 500 employees, they're probably covered by the FFCRA. And then we have to figure out if what the employee is reporting is one of the protected leaves. In this case, because he does not actually have any symptoms, he's just deciding it's a good idea to get a test, he actually is not covered under one of the emergency paid sick leave categories. That's reserved for when someone has symptoms and they're seeking a diagnosis, okay? So that's an important distinction here. So now we need to think about, does he have any paid time off, whether it's a sick time under a sick time policy or a general PTO policy? What leave does he have available under your regular policies? And at that point, you know, the EEOC and the DOL are encouraging employers to be very flexible with these policies. Certainly you want to encourage testing, right? So you can find out what's going on. So in this case, if he has the leave, if it fits under a policy, you absolutely want to make sure he knows what's available to him. And then how long should he stay home? Well, according to the latest CDC guidance, even when there's no symptoms, you really do want employees to quarantine for 14 days if they have probably been exposed or have confirmed exposure to the virus. The alternative to that could be 2 negative tests that are taken at least 24 hours apart. But you do want to be consistent with the CDC and any state or local guidance on the subject. I'm sure you're all aware it changes constantly, so you do want to keep checking back on a regular basis. Finally, we have the other 2 maintenance workers to consider. In this case, and I believe Lauren went over this earlier, you're going to want to notify them that they were working with someone who may have been exposed and they should monitor for symptoms. At this point, they do not need to quarantine because we don't have any confirmation that the first employee has COVID, but you want to let people know generally to be on the lookout. But again, we're not going to provide any specifics of the employee's name. Even if the maintenance workers can figure it out, you are not going to tell them who you're talking about. Dina, you're on mute. Oh.
I got it. I had to juggle too many things there. So PPE and accommodations. As we come back to work, one of the big questions is, should we be requiring use of personal protective equipment in the workplace as recommended by federal, state, and local governments? And the answer is, of course, right? CDC and different states are saying yes, we should be requiring PPE. A big question that's come up with a lot of our clients is, what do we do when employees refuse to wear PPE or are seeking accommodations? So we've had some very interesting situations, and we're not dealing now with the public who's refusing to wear PPE, which is a whole different scenario, but where individuals who are employees are saying either they won't wear it or are seeking accommodation because of disability or religion, frankly. How do we deal with it? So what we're encouraging our clients to do is what's required under the law: engage in the interactive process to determine if a reasonable accommodation can be made. And you know, one situation that happened to a client recently had to do with an employee engaging with the public as part of her job, but the member that she was engaging with was deaf. And so not only was she refusing to wear the PPE, but she was also indicating that in doing so, she could not perform her job. And that's a classic example that actually the EEOC talks about in its guidance. In that case, it's not just, you know, there's a lot of different forms of PPE out there, right? There's shields, there are masks that are actually clear that they could give. And so at the end of the day, there are, what our requirement is to sit down and discuss with this individual, what are the limitations, what are the restrictions, and how can the individual continue to perform the essential functions of their job while we assist them in doing so by relieving them of one of these issues that they're asking for, but still allowing them to do so. So in this case, we offered all of these other solutions and one was chosen. Oh. Okay, I seem to be going in the wrong direction here. Hold on a second. Okay, so Peter supervises retail employees at a local clothing store. Peter tells his manager that he cannot wear a face mask at work as required by company policy because the mask is uncomfortable to wear with his glasses and makes it difficult for him to breathe. Peter cannot perform his job remotely. Does Peter have to wear a face mask at work? And before we get to the answer, we have another accreditation code, 530271. Again, 530271. Okay, so Peter, does Peter have to wear a face mask at work? So first, the comfort of a face mask is not a legitimate excuse to violate an employer's safety PPE policies, right? And we've had this issue come up in the religion context based on various religious garb that an individual has to wear, and a face mask could not, a standard face mask was not able to fit. But again, working with the individual, we were able to offer various solutions for that. So, you know, again, is it comfort? Is it a religious accommodation? Is it a disability accommodation? Let's figure out what the request is and then decide what solutions we can provide. Having difficulty breathing, however, could relate to an underlying disability that is covered by the ADA. So, what is the obligation of the employer? To talk to Peter and find out more information about his request. Consider if the interactive process is required or if alternate PPE could be considered, right? A face shield or plexiglass wall for desk space or other things like that. So again, that's what's required of you, right? A discussion with the employee. One of the things as we go through this that I also want to mention is we should never assume that the individual has a disability, because that could put us in a precarious position under the ADA. But we want to say, what can we do to help you, right? Is there an issue that you have? What can we do? And then we listen and we go from there.
So while we're covering common issues, let's do another hypothetical. So Kalo College hired Jim 6 months ago, and he's the administrator of student affairs. He's been reporting to work daily, but he tells HR that being in office makes him very anxious and he can't focus on his work. Jim mentions that he would prefer to work remotely, and he's going to discuss his anxiety with his therapist. So should the college allow Jim to work remotely? Well, there's a few. The first thing is to analyze what he's requesting. So next slide. So it looks like he may be requesting a reasonable accommodation. He's not requesting time off. He's not requesting a period of leave. And just because Jim is a newer employee with only 6 months with the organization, that doesn't matter. There is no minimum service requirement to be protected by the ADA and be entitled to a reasonable accommodation. So though I think all of us could relate that there's been a lot of stress, just ambient stress due to the pandemic, there are certain employees with diagnosed mental health conditions that could have a disability related to their anxiety under the ADA. And Jim did mention that he was going to talk to a therapist, so that should perk your ears up that this could be an ADA related or covered disability. So Kalo College should respond to Jim's request by engaging in an interactive process. And as Lisa mentioned earlier, the undue hardship analysis may have changed from the pre-pandemic time, from a request to telework. So there's been a period where a lot of organizations have seen their employees prove that they can work from home very efficiently. So keep in mind that your undue hardship analysis could be different than it was several months ago. So one last very interesting issue is the possibility of leave fraud in the era of a pandemic. So playing hooky in a global pandemic is a lot different than it used to be. So if an employee fakes a COVID-19 diagnosis, it's not just them missing work. It could require coworkers to miss work. It could cause full facility shutdowns or other interruptions to business. And in the news lately, there's been some high-profile cases where employees in, for example, South Carolina and Georgia, who worked at a manufacturing facility, faked a COVID-19 diagnosis and caused a full facility shutdown, which resulted in hundreds of thousands of dollars of lost revenue. They are now facing criminal charges. So next slide. Though it's not a common issue, the fraud may not be a totally common issue, but there are some measures that employers can take to protect against it, such as requiring a doctor's note to confirm each and every COVID-19 call-in. And then once you receive that note, take some measures to look up the doctor's office and make sure that the note itself is consistent with the location, the provider who signed, and look for any inconsistencies in the letter that look like it was just someone hammered it out on a keyboard and hit print. And with proper HIPAA authorization, an employer can contact a provider's office to confirm or verify the contents of a doctor's note if you're especially suspicious.
So we had one question about Tricky Trisha earlier, and whether if she never provided the doctor's note, what could be done? And in answer to that, look, if she never provides the doctor's note and it's determined that she had failed to give appropriate information to you, or was lying about her diagnosis, or just keeps putting you off and never provides it, then she's violating your policies, and you can follow your policies, which, depending on what they are, if she's already at the end of your disciplinary process because she's taken unexcused absences, then she can just go to the next level of that process. I would give her a little time. You know, right now with telemedicine and the way things are going, it seems to me like you should be able to get in front of a doctor relatively quickly. But if she never does, and the doctor's note never comes in, then that's an unexcused absence like any other. She doesn't get FFCRA benefits, and you can take her to the next level of discipline. So we are at best practices for employers. I know we have some questions on the chat. I unfortunately, because I'm sharing my screen, can't see the chat. So I don't know if we want to address them now before we go into the best practices. Lisa, I don't know if you want to cover some of them. Let's see.
So the question I saw was related to one of the hypotheticals. I think it was with the maintenance worker. And the question was, does the requirement to quarantine for 14 days now qualify the employee for emergency paid sick leave? I think that's the hypothetical we were talking about. So anytime somebody's quarantining, you have to go back to those 6 factors on that DOL poster that I think has been provided as part of your materials. But they are, is the employee subject to a government mandated quarantine? In that situation, the answer is no. Has the employee been advised by a healthcare provider to self-quarantine? Again, the answer would be no. And then, is the employee taking time off to obtain a medical diagnosis or to care for someone who's under quarantine? The answer is no. So there's a difference between an employer instituting a precautionary quarantine versus a medical or government required quarantine. So that's where you would look at those factors to determine whether the period is covered by just regular PTO or FFCRA. So hopefully that responds to your question.
I'm just going to follow up on that because it's going to go into some of these best practices. You know, there's a lot of travel orders right now that say if you travel out of the state of New Jersey, for example, and go to hot spots, right? If you come back to New Jersey, you have to quarantine. But there's also a lot of misconception about what those orders say. But if there is an order in place that says that you have to quarantine after you leave the state, once you come back, if you go to certain places, is that a quarantine order? You know, under this law, that means that the individual would have to quarantine, and would they get paid for that? You know, if there's an order in place, the answer is yes, that there's a quarantine order. In a lot of places, though, those orders are just recommendations. They're not actually orders. And one of the things that we have been recommending in the event that there is no actual order in place, but it is highly recommended by the state or locality, is that we change leave policies to include the fact that if you're voluntarily going out of state and going on vacation and then coming back, that you have enough PTO in your bank to cover the time that you're going to have to quarantine under any recommended state, local, state or local quarantine order or recommended quarantine policy. So that's an issue that is an interesting one that we've been working with clients on, because there are a lot of those travel bans or restrictions out there right now.
Dina, we've had a number of chat questions come in now that we've opened the floor and the floodgates, which is great. I'm just wondering, for timing purposes, would you like to address a few more of these now, or should we save those for the discussion groups?
No, let's address some of them now. We have a few more minutes, and then I can just run through the wrap up. But I think let's address some of them now. I think we have another 8 minutes or so that we can run through questions.
Sure. Okay. So then the next one is, can you discuss the direct threat analysis for employees requesting a face covering exception, given the CDC and state law requirements that a face shield does not protect from COVID like a face covering does? So if I'm understanding the question correctly, I guess, really, what can you do when an employee is saying that they can't wear a face covering, and you're trying to figure out what the alternatives are and make sure that the workplace is safe for the employee and for others? So I think it depends on the situation that the employee is working in and the circumstances. Are they someone who is going to be within 6 feet of others? Are they in a customer facing position? My understanding for the most part is if somebody were to be offered in most jurisdictions a face shield and they can social distance, in most cases that would be sufficient. The alternative would be working from home, or talking to the employee about, is there a type of face covering that you and your doctor are comfortable with, right? Because there's all these different fabrics and materials and styles out there. So what are these employees wearing when they go out? I mean, in a lot of states, if you go to a store, you go anywhere, you have to have something covering your face, even if you maybe have an underlying condition. So what have they been using? So it's a fact specific question. And it does depend on their job, and ensuring that they can also social distance, ensuring that you have proper cleaning supplies. Do you have plexiglass? Do you have a partition that you can put up to even add to that environment to make it more safe for others? Those are all the considerations that come to mind that I think you would want to walk through with that individual.
So there's another question that I saw about written consent. So I know this is a question on everybody's minds. Somebody comes down, is either exposed or positive, what can we say? And if the person actually gives consent to reveal who they are, can we then reveal the name? And, look, when somebody gives consent and says, yes, you can use my name, the answer is yes, you can give the name. I would be very careful that you get proper documentation of that. And, if it's absolutely necessary for contact tracing purposes, then certainly you can do it. And just as a quick example, my son is in school, is actually going to school every single day. There was an exposure issue. His dad, the kid who was tested positive, his dad's actually the principal at the school. But so he gave permission. They actually said the kid's name. And they said, anybody who was in contact with him, from last Thursday forward, let us know, because we're going to isolate. And so, is it permitted? It is. It's permitted. I would not want the employer to be looked at pressuring the individual, right? We just have to be sure that if it's voluntary, it's truly voluntary. So are there any other questions?
There's a number of other questions, so I'll just keep going down the line.
Okay.
And I will say I'm going to target questions that I think I can interpret pretty quickly. Some of these are pretty case specific, so you can please reach out either in your interactive discussion group after this, or you can email any of the presenters with your questions if we don't get to it. Another question is, if an employee has tested positive but was able to work remotely, can you still ask for a doctor's note? And the answer is, if the employee missed any work because they were seeking a doctor's note or a medical diagnosis, absolutely, you can ask for a doctor's note, right? The difference is if they're working remotely, they're still getting paid for all the time worked. So that time that they're working remotely is just treated like regular work time, and it's not covered under the FFCRA.
I guess my issue there is if they are supposed to be in the office, but are now working remotely because of an allegedly positive test, then my answer would be yes, you can get a doctor's note for that.
Absolutely.
Yeah.
The next question is regarding school closures and expanded FMLA. Does the EFMLA solely refer to physical closure of school facilities? Are schools considered open if students are learning virtually? That's a great question. We get this a lot. So yes, we are speaking about physical openings where the child can go to school or go to daycare and learning is available there. So for virtual learning days, FFCRA would apply because the student is not able to go to a facility for teaching, instruction, and care, right? So if you're in a school system or your employees in a school system with a hybrid program, the virtual learning days when they're at home, if the employee cannot also telework, that's probably covered by the FFCRA and the EFMLA. The next one I'll read and then I'll throw to Dina. Somebody works for a medical practice and they would like clarification on letting staff and patients know if someone has symptoms or is positive. You mentioned coworkers can't be told if a coworker is sick. We also mentioned about needing to contact trace. I think we went over this a lot, but Dina, is there anything else you want to follow up in that particular setting?
To clarify, you can and should be telling anyone who was exposed to a positive case that they were exposed potentially to a positive case. You just can't give the name of the individual, even if you think they may know who it is by saying you were exposed to a positive case. You just can't give the name.
And one thing I want to add real quick, whoever is suspected of having the virus, you absolutely should with that person ask them, hey, who do you remember being in contact with in your last few days of work? So that's another way to do contact tracing, is having the person who is suspected or confirmed tell you who they were in contact with. They may not remember every single person, but it certainly could be helpful for contact tracing purposes.
Okay, so at this point, we're going to wrap up. For those whose questions didn't get answered, you can follow up with us by email, or we can chat with you. There's going to be a 15-minute break between the next presentation and the breakout session, so we're certainly happy to interact with you during that time. So best practices for employers: you need to update your leave policies, or at the very least, because I know some employers are hesitant to update their leave policies because FFCRA may go away. So at least issue some guidance or guidelines and a memo to employees on what the FFCRA is and how to avail themselves of it. Post the required notices. Train HR and managers, frankly, on this new policy. Have procedures for reviewing COVID-19 leave requests and medical certifications, and certainly maintain complete and accurate records. And if they're medical records, keep them in a medical file. We want to be monitoring government orders. I will say that many law firms right now, including ours, are putting out blogs and information about government orders as they change. Utilize those firms, including ours, as they evolve in different phases in different states and localities. Luckily, many of these orders have, we're getting out of the red and into the green, although from what we're hearing, we're going to go back into the red, or we may go back into the red. So we just have to be cognizant of that. Plan and prepare for the second wave. I heard a great story about a company where a friend of mine works. They were already prepared for a pandemic and pandemic preparedness before any of this began. I was surprised and happy that he was ready for it. Many of our clients were not. And evaluate what worked, right? Now that we're at least through this point, see how you did, right? Think about that. Many of our clients have put together pandemic task forces, and I think that's a great idea. what policies were good, what policies aren't working, and let's kind of rework that as we move ahead out of 2020 soon, hopefully, and into 2021. And with that, I am going to stop sharing my screen and I think move on to our next litigation trends presentation.
Okay. All right, let me share my screen. Okay. Dina, do you mind just giving me a thumbs up? Do you see one or two slides on your screen? One? Okay.
It's one, Jillian. You're good.
Thank you. So good morning, everyone. Excited to be talking to you all today about some of the anticipated COVID employment-related litigation trends. This year has been a very challenging year for everyone. And one of the things, the issues that we deal with on a regular basis are always complicated. We're dealing with people's livelihoods, we're dealing with people's health. This year, on top of all that, we are dealing with something that's brand new. This is not something that we've ever had to deal with in our lifetime. So, one of the great things that we're doing is sharing data, sharing information about what is required and also what has worked. A lot of what we're talking about is practical information. What should we ask from employees? What do we do? What will work with an accommodation? So some of this comes from experience and some of it will come from the cases that we're seeing. So the issues that we're seeing, first, the unprecedented work from home arrangement. I remember back in March when this started, we were thinking, May 1, June 1. Now I'm hearing that a lot of employers are saying sometime in 2021, and other employers are saying we're going to totally reevaluate our return to work or our office space and how we operate in the office. The other issue that we're seeing is there are new federal and state guidelines and requirements coming out now probably on a weekly basis. Back in March, April, it was a daily basis, and there would be guidance published by an agency, and then the next day it was revised and changed. And it's a lot of information to keep up with, and it's very challenging to make sure that we are following the most recent guidance and implementing that correctly. We've seen layoffs, furloughs, and recall issues. Back in the spring, a lot of companies were evaluating, do we lay off? Do we furlough? Do we know how long we're going to have to furlough somebody? We furloughed people and then a month later realized we were busier than we expected to be and we have to recall people and deciding who we're going to recall. And then on top of all these brand new things, we're still dealing with the same employment issues that we have always dealt with. So the areas that we're going to talk about and that we reviewed the data from, first, discrimination, but primarily pretext. So cases where it's alleged that the employer is maybe taking advantage of the COVID situation to take certain employment actions that pre-COVID may look way more like pretext, but and it still is pretext, but there's been some cases where it's been alleged that discrimination is, the COVID is pretext. We looked at reductions in force, the criteria to select those who will be laid off, selecting those employees to be furloughed, and then recalling people to work, deciding who to recall. If we can recall an entire department, great. If we can recall an entire location, great. But what if we can only recall a percentage of those employees? Making those decisions is something that we're going to talk about. We're going to talk about accommodations and leave, of course, probably the biggest area FLSA and different timekeeping issues that come up, whistleblowing and retaliation claims, FFCRA, WARN issues that come up, and then something that is relatively new that we're seeing in different articles that come out are claims alleging take-home COVID. So it's an employee who may have been exposed at work who then goes home and one of their family members is exposed and may get sick. And unfortunately, in some cases, we're seeing wrongful death suits. And that, is something, if it can be traced back to the employer, it's something employers are being mindful of. So the data we reviewed between March 1 of this year and October 15th of this year, and we reviewed federal court filings. So these are new complaints that have been filed in basically a 6-7 month period. There have been over 800 lawsuits filed that in some way reference COVID, and a lot of it is combined. It can be, accommodation issues, discrimination issues, whistleblowing issues, OSHA issues. A lot of it's combined, but they're all related to COVID and employment. The states where we're seeing the most filings are California, Texas, Florida, and New Jersey. The common case types. So the first one that we're seeing a lot of, like I mentioned, is accommodations and leave and requests for remote work. Because a lot of employers were able to, some employers were able to allow employees and make it available to work at home for a period of time. There's a lot of employees who now expect that that will continue. And because we provided it at one time, can we no longer provide it? Are we being reasonable in saying it's not an appropriate accommodation? And if there are any discrimination cases that come out of that. The other common case types are whistleblowing and retaliation. Retaliation, especially, an employee makes a complaint that somebody's not wearing a mask or that they may have been exposed or somebody's not following a policy and they're being retaliated against. And finally, discrimination, like I mentioned, the pretext, RIFs, furloughs, and recalls. So the potential litigation risk areas, starting with reductions in force, it's both the handling of the process in layoff and rehire. So when we are conducting a layoff and choosing who to include, we want to make sure that we are using objective business criteria. We do this in a variety of ways through impact analyses, and it involves spreadsheets and data, and we look at seniority dates, and we want to make sure that we have the managers or the department heads who are ultimately making the decision, but then also legal and HR who can check those decisions to see if there are any trends that could be discriminatory, and making sure that we kind of put that check and balance in it. Then once people are furloughed and we're recalling them, we're seeing claims where employers are being selective in who they're choosing. They might be choosing, we've seen cases where the employer knows that one of their employees is has kids at home and might be struggling with school issues. And so the employer doesn't select that employee to be recalled. If that employee should have been recalled, but for the childcare issues and there's no accommodation, there's no leave issues, that could be a pretext and discriminatory. On top of the issues that we were seeing with recall, some municipalities are actually passing right to recall statutes. So they're passing legislation, we've seen it in California, where there are certain rights to be recalled, certain orders that are being recalled. And I suspect that as unemployment is running out at the end of the year and employees are wondering if they're not currently recalled when they're going to be recalled, we're going to see more of a push for similar legislation. So it's something we want to be on the lookout for. lots of age discrimination pretext cases where an employee has used COVID and used these furloughs to, in essence, force some people into retirement when that's not what they were looking, and laying off a whole group of people and then recalling people. But when we look at the numbers, when we look at the data, we're seeing there's been claims where older people are alleging that they are not being recalled based on their age. We're also seeing claims that are somewhat related because people who are over the age of 65 are at higher risk for COVID complications. And so we're seeing some employers make decisions based on that, which of course we cannot do but for an accommodation request or some sort of further conversation with the employee about a disability or a serious health condition. A lot of pregnancy discrimination cases are coming up in these COVID-related claims. And that is both in the decision to furlough or recall somebody, but also in accommodation issues. Pregnancy by itself is not a disability. Pregnancy-related medical conditions could be a disability, but COVID poses a higher risk of complications to pregnant women. And so we've seen a number of both requests for accommodations come in and claims, ultimately, if it was denied, when the pregnant employee might be denied the accommodation request. So some of the case examples that we're going to talk about. The first one, it's a New Jersey state case. It is where the plaintiff, it's a pregnancy case. The plaintiff sued her employer under the New Jersey law against discrimination, which those of you who are not familiar with New Jersey, it's basically the equivalent of Title VII, alleging that she was treated differently because of her pregnancy. She was informed by her doctor that she had a high-risk pregnancy. One of her coworkers tested positive for COVID. She became concerned that she was high risk and asked if she could be furloughed. Her employer was furloughing some employees, but was not furloughing her specific position. The employer denied the request, but accommodated her by putting her in a different area, which was a lower risk area, and the employee agreed. She thereafter received a negative performance review and was terminated. Now she's alleging that this termination was in retaliation for requesting an accommodation due to her high-risk pregnancy. We've seen a California case alleging religious discrimination. So the point I'm going to just touch on with religious discrimination, we've seen some claims with temperature checking where employees based on religious practices have requested a person who checks their temperature of their same gender. That is something that's come up. In this particular case in California, the employee's religious institution was closed because of COVID. And so he began praying at work, in the workplace. At that point, management became aware of his particular reason. He was ultimately terminated, and he alleges that he was terminated due to religious discrimination. And this stems out of circumstances that were ultimately created by COVID. The last case I'll mention, it's a Michigan case alleging age discrimination. I had touched on it a little bit before, but this is a specific where an employee was employed by this employer for 28 years, was furloughed due to COVID. He alleges that his work performance was superior, but that he was not recalled, but instead offered a severance agreement and offered separation. And he alleges that it was pretext for age discrimination. So what can we do to mitigate risk? First, whenever we're doing a RIF a furlough or a recall, we want to have documentation of the reasons behind our decision. We want to be able to show the data. A lot of times it's an Excel spreadsheet. We want to make sure we have different people in different departments having eyes on it, that we're separating the confidential information from the managers, and that we have concrete reasons as to why certain people are being termed or furloughed versus others. You know, if we can treat everyone in a department equally, and if we have enough work to have 50% capacity, we have the option of furloughing 50 people. We also have, or 50%. We also have the option of furloughing everybody with their hours at 50%. You know, depending on how your business functions, the second option might be a little bit safer because you're treating everyone the same. When we are returning to work, same thing. It's the exact opposite of the decision to implement a furlough or a RIF. We want to make sure that we are applying the reasons equally. And again, documentation, emails, spreadsheets, and then if we are implementing policies, because we are seeing so much change on a constant basis, we need to make sure that we are reviewing our policies probably on a weekly basis or whenever we know that there is legislation that could affect it, because we want to make sure that the policies that we're relying on are up to date and it's what we are actually doing. So moving over to the FMLA and the ADA, and a lot of this is combined, but the risk areas that we're seeing, the litigation that we're seeing, first, vulnerable employees. So employees who have compromised immune systems are requesting accommodations, requesting leave. And there's a question, do they actually have a disability or a serious health condition? Being high risk by itself is not a disability or a serious health condition. And so we might know legally it is not covered under the ADA or the FMLA, but practically speaking, it is a risk area. And if you have an employee who is high risk and who does not feel comfortable coming to work, it is going to be an area that is risky. In FMLA, caring for a family member, if an employee has a family member who is high risk, we've seen a lot of requests in cases where the person alleges they were denied FMLA to care for a family member, but really they were not caring for the family member. It was to limit that exposure for the family member, and that does not fall under the definition of to care for. Other areas, quarantining and actual exposure. If somebody is exposed in the workplace, there is the safety issues, there's the contact tracing, and then any decision we take against that employee or other employees who have been potentially exposed is something that we need to monitor. And finally, we've talked about remote work, and that's just another area that, of course, we're seeing come up. So a couple of the FMLA and the ADA case examples. So we recently saw an Eastern District of Pennsylvania lawsuit alleging failure to offer FMLA. So the plaintiff alleges that he attempted multiple times to seek medical diagnosis, to self-quarantine at home because he was a high-risk individual. The company declined his request, or effectively did not consider it, did not take it seriously, did not send FMLA paperwork. And the plaintiff employee alleges that defendant failed to, or the employer failed to offer him FMLA. So it's one of the things that we want to get in the practice where if an employee is requesting leave or an accommodation, even if we think that it might not qualify, we want to get in that practice of sending paperwork to the employee to help mitigate that risk. There's an ADA case, a California ADA case, where the employee alleges that she was discriminated against based on her pregnancy, that her employer interfered with her pregnancy leave, and that she was retaliated against for requesting pregnancy disability leave. She was concerned about contracting COVID-19 in the workplace, and she asked her employer to implement certain safety precautions in the workplace to limit that exposure. This is an area that we are seeing over and over, where we're telling employees who may be high risk, but we're denying the accommodation, that we are putting in safety protocols, we are requiring masks, we are social distancing, but then we're finding out that those practices and those policies are not actually being followed in the workplace. And so this employee who may have had a claim for failure to accommodate also then has a potential whistleblower claim, a potential OSHA claim, or a safety claim. And so it's different things that are coming up. So what can we do? One, develop clear safety protocols for employees returning to work. And it's not just developing them and putting them on paper. It is training managers. It is implementing them. It is constantly reminding employees of what our protocols are. We need to train managers to, one, implement the policies, implement our procedures and our protocols, but also how to identify risk, how to respond to these requests properly, handling confidential information. We've seen a lot of cases where a manager or an employee comes in or advises their manager or their coworker that they had been exposed, and that information has unfortunately been shared around their workplace, which could be, which is a violation of the confidential information. And finally, we want to be practical when considering accommodation requests. We follow the legal requirements of the ADA and the FMLA, but we also are recognizing that the workplace has changed a lot this year. And we want to make sure that we are evaluating our business operations in connection with what is going on, because this is not something that is going to be done on December 31st, unfortunately. It is something that's going to affect our business for a while. And an accommodation that we may have never considered reasonable 6 months ago or a year ago, there may be certain steps that it'll be to our benefit to implement and something we want to consider. And with that, I'm going to pass it along to my colleague, Ruth.
Let me unmute myself so I can avoid the inevitable "you are muted" while I start talking. Thank you, Jillian, for that. We're going to move on to wage and hour and FLSA claims, because what is an employment seminar without a discussion of the FLSA? You can go ahead and go to the next slide, Jillian. So, when we're going to try to avoid this being kind of a primer on the background of the FLSA, I'm going to toss some things in there just to make sure we all remember the differences and why this can be a particular issue as it relates to COVID. The first thing I want to say that we should always keep top of mind is our obligations as employers under the FLSA will continue whether or not our employees are working in the office or whether they are working at home or teleworking or working remotely. So our policies, our procedures, all of that stays the same, and we have to make sure that we're reviewing it and enforcing it and communicating it. Now, that's going to look a little different to some of our employees, depending on whether they are exempt or not exempt, right? So our salaried exempt employees, remember, we have to pay them for any week they work. And for our hourly non-exempt employees, they get paid for each hour work. Time is money, right? So every hour they work, we have to pay them, which means we need to keep track of their hours, which can be particularly challenging in this context. Now, before we move on to some other issues, I do want to just do a little bit of background to remind everybody what we're looking at if we have FLSA violations, right? We could be looking at a DOL enforcement action, and we could be looking at the favorite of the plaintiff's bar, which sometimes is a class action or collective action under the FLSA, because the specificities of these type of cases are well suited for class action or collective action pleadings. Whether they hold up is a wholly different story, but they do lend themselves to be pled that way with respect to claims. So what kind of damages can we get, right? There are wages, there are liquidated damages, there are attorney's fees. And I want to point out that while the FLSA, is the federal statute, a lot of states have their own wage and hour statutes, and states like New Jersey have adopted extremely stringent wage and hour statutes. I believe we called that the wage theft law when it came out, and it changed and amended a lot of different wage and payment and wage and hour laws in New Jersey, but it has some significant penalties that come along with it and damages. So, you know, while this is something we deal with on a regular basis in terms of how we pay people, violations and problems that arise out of it can be very expensive to deal with. So we want to make sure that we're developing a comprehensive approach with respect to our employees that are in the office and our employees that are out of the office. So let's talk a little bit about what the issues are here in this non-traditional working environment that we're dealing with. You can go to the next slide, Jillian. So for our non-exempt people, accurate time keeping practices really seems to be a big issue in this particular type of environment, because we have remote employees that are not sitting in the office, that are not, you know, in and out on a regular basis. They're working from home, and the same policies apply, right? Breaks apply. They should be taking their lunch breaks. They should be clocking in and clocking out. And part and parcel to that is going to be communicating with not only the employees, but also their managers and supervisors as to what the requirements are and that we're following our same policies here. But because folks are working in a different environment, it could lead to a little bit of lax clocking in, clocking out, what they're doing, when they're doing it. And we want to make sure that we're monitoring that. For exempt employees, I think the biggest issue that we've seen here is, did their duties change, right? So just as a little refresher, for our exempt folks, we've got to meet three things, right? We've got to have our salary level test. They have to be paid a certain salary per week. They have to meet the salary basis test, meaning they're being paid on a salary each week, regardless of how much time that they work. And we have this primary duties test that qualifies some of our employees for whichever exemption it is that we're claiming. And the duties test is dependent on what they're doing. So remember, I think this probably came up a little bit more at the beginning of the pandemic when it started coming out and we started furloughing, or we started to work with less employees, and duties and what folks were doing were changing. So for example, if we had a manager that was managing folks and their duties were covered and their duties were squarely within that exception or that exemption, and we've let people go and that person has started picking up a lot of different work and a lot of different type of things, they may have lost their exemption. They may have fallen out of that duties test. So let's take a look at how we've restructured and how we've moved people around to make sure that if that's an issue, we're aware of it, because that could lend itself to an FLSA claim. Also, if we've adjusted salaries in any way, we want to keep track of that. We can go on to the next slide, Jillian. The other issues that pop up are off the clock work. And I'm going to skip the first bullet for a second and just talk about the next ones kind of in conjunction. When we're working remotely for non-exempt folks, these are folks that may not have had access to email outside of work. They may not have had access to smartphones. We may have, that just may not have been something that existed. Now it does. And I think there's really a danger here to always being on call. Is that person, if they feel like they have an obligation to respond to emails after they've clocked out? Do they see something on their phone and feel like we need to respond to that outside of our regular work hours? That goes, and I think that knife cuts both ways. It's talking to these non-exempt employees, making sure that the communication is clear that we're not working outside of work hours because we're not doing that. That's against our policy. But also on the manager supervisor level, don't be sending emails after hours and expect a response. So the communication is going to be very key there. The other off the clock work, which is where we have seen litigation, and I'll talk a little bit about that, is when there are activities related to COVID-19 safety procedures that are taking up additional time, and whether that time is compensable or not. And I'll go through a case here in a minute to kind of illustrate that. But that is definitely an issue that has popped up in the realm of COVID-19 and the extra protocols and policies that are going into place. Another thing to think about is expense reimbursement here. I'm going to just highlight California. It's got a very specific rule about what has to be reimbursed and how. Internet usage may qualify for some of those things. Equipment may qualify for some of those things. And it could lead to certain claims if it's not being properly reimbursed. So those are all things to look at. So what can we do as we're looking about this? One, communication is key. We need to be very clear with our employees and communicate effectively and clearly what work from home expectations are or remote work is, our expectations are, if we still have folks that are working remotely. What, you know, with respect to breaks, with respect to clocking in, with respect to overtime, compensable time, and what folks are doing. We also need to have a clear understanding of how we're tracking that time. It might be a little bit different than when someone is in the office, and we need to make sure that we're doing that effectively and that we're potentially auditing how we're looking at that. You know, do we have inaccuracies built into that system that we need to look at for folks that are working at home? If salaried employers are working non-traditional hours, we need to make sure that they're not expecting our hourly employees to also be available. This goes right into this, you know, after hours communication and feeling the need to respond, and it really can result in some issues on compensable time. And the last thing is when we're looking at our salaried workers, we need to keep an eye on those duties and see if they fall out of the exemption category. So that is on our radar. If we have to review or revise job descriptions, move things around, it's something we should be cognizant of and looking at. And I think now is a really good time to do that. We were a little bit in, you know, panic mode at the beginning of this and moving folks around and getting people where they needed to be. If we had to lay individuals off, furlough people, and reassigning tasks, you know, if we're watching the news, we're probably going to be back in a little bit of that situation potentially in the fall if what is being reported plays out. So now is a really good time to start planning for that and start looking at how folks are being assigned and what their duties are. So let's just talk a little bit about one of the cases that we've seen in the FLSA kind of realm here. And I alluded to it a little bit earlier with respect to the compensable time for COVID-19 protections that have been put in place. So this Evans case, it was filed in the Northern District of Illinois. And these were Department of Corrections officers in Cook County. And really what the allegation focuses on is that there were very stringent procedures put in place for individuals that were reporting to work in terms of what they had to do before they came in, when they came in, and when they left. It included sanitizing, personal protective equipment, suiting up, getting things ready to go, and leaving. And what they've alleged is, look, that's compensable time. I was not paid for that. I had to engage in that behavior and those protocols based on policies, based on the COVID-19 pandemic. I did, and I wasn't paid for that. The allegation in this complaint is that took about 20 to 30 minutes. I think we're going to see more of these. This is a fairly extreme example of something that led to a complaint because the amount of protective gear and what was being done was taking a significant amount of time. I think you have to balance that when we're looking at just filling out a health questionnaire before you come in or things of that nature. So look at the policies that we have. What are we requiring employees to do, particularly non-exempt employees? And is that creating or taking enough time to be potentially compensable time? So that's really the FLSA. I think we're going to see some more claims come out of that, but it's something to keep our eyes on and be aware of. The other type of claims that we're seeing that Jillian mentioned at the beginning were whistleblower retaliation claims, right? They kind of go hand in hand, meaning I complained and I've been retaliated against based on some adverse employment action that was taken. So what kind of risks do we have there? And we've previewed some of these before. Before I start, accreditation code for those of you paying attention to the bottom in the red here, it is 421998. That's 421998. So let's talk about some of the risks that are associated with whistleblower retaliation claims. And a lot of these are going to stem from unsafe working conditions or exposure issues at work, failure to implement safety policies and procedures, or right on the back end of that, failure to actually follow the safety procedures and policies that you've implemented. We want to make sure that we're training folks, failure to train individuals, supervisors, employees, failure to provide PPE, failure to reimburse for PPE. These are all things that could lead to a potential whistleblower claim. And I want to talk just briefly what those claims could look like. So one type of whistleblower claim is a statutory claim. So the one that I have up here, if you can go to the next slide, Jillian, is New Jersey as an example. For those of you that are in New Jersey or practice in New Jersey, You probably recognize the term SEPA. It is the Conscientious Employee Protection Act, and that is a codified statutory claim for whistleblowing, essentially. And what it says is it's unlawful for an employer to take any adverse action against an employee who objects or refuses to participate in any activity, policy, or practice. And this is the important part of SEPA, which the employee reasonably believes is, and then it provides a series of things: the violation of law, rule, regulation, fraudulent criminal activity. And then the third one here is incompatible with a clear mandate of public policy concerning the public health, safety, or welfare or protection. So, and there's been some additional commentary about that. So those are statutory claims. We also have common law claims that can pop up. Maryland is an example where it's recognized through the court systems or through the legal system that there's a potential whistleblower claim, but we don't have it codified in the same way that we have it in New Jersey. So what can employers do? The first thing is implement safety policies and procedures. And maybe we should give out a nickel for every time we've said that in this presentation. I know Jillian said it a lot as well, but we want to make sure that we have those procedures in place, that they comply with state and federal laws and their guidance. And more importantly, that we actually follow the procedures that we have in place. They're only going to be as good as what we actually do. So having a really good plan and training everybody on it would be great, but if we're not actually doing it, that's going to create a problem as well. So training, and more training for our employees, for our supervisors, for everybody up the chain and down the chain to understand that the health of our workforce is important and this is what we're doing to protect it. Another thing that you can do is consider designating a point person for your COVID-19 issues, because I think a lot of this is new. The training, we have a lot of folks that are out there kind of dealing with this on the ground level with employees on the day-to-day basis. We have folks higher up that maybe not seeing the same issues, and we may miss things, or things may not will not be brought to the attention of those that need to hear about it, or we're not able to do something about it. So having a point person could be a good idea. A lot of companies, businesses, employers are designating COVID-19 task force or teams, so that they are handling and staying on top of most of these issues and they can deal with them as they come up. So I want to talk about two cases where we've seen whistleblower claims asserted. This first case is Duffy versus Berkeley Heights Dental Group. This is in Union County, New Jersey, and it is underneath that statute that I just mentioned, SEPA. This was a dental hygienist, and I'm going to make a caveat for this case and the next case because they both deal with folks that were working in the healthcare context in that industry, which has some very specific guidance and rules they have to follow. So in this case, we had a dental hygienist. They closed down, everybody went home. They decided to open back up. They were coming back in, and this individual raised some significant complaints with respect to the reopening requirements and their compliance with the state rules and what the governor had put out in executive order, as well as subsequent administrative orders dealing with this particular industry, ranging from PPE to cleaning to a whole host of things. And I think, and the complaint alleges that those complaints were raised systemically and a lot to several people, and each time were dismissed or blown off or not taken seriously, and in fact were met with some hostility from management. Eventually, that individual alleges that she was terminated, and then she asserted a claim under the New Jersey Conscientious Employee Protection Act for the entity's failure to actually follow the rules and guidelines they were required to follow. The other case that is in here, this Monty's case, this was a nurse practitioner, and it's similar fact pattern. It is someone that was working and made objections with respect to the type of PPE that was being provided and the lack of social distancing and not complying with the safety requirements that were required. And that was met with hostility from management. This individual claims that once he started complaining, his schedule started being changed, things were made very difficult for him, and he was terminated within months of making his complaints. And he has also alleged a complaint under Florida's Whistleblowing Act. So these are the type of claims that we're seeing pop up. There are a lot of them out here. This is a good example of some of them, but we expect to see a lot more of them. So with that, I'm going to turn it over to Anna Maria to cover the last bit that we have today.
Thank you, Ruth. So as Ruth said, I'm going to be covering the last two issues that we have for our presentation. The first area that I'm going to cover is enforcement actions and litigations under the Families First Coronavirus Response Act, the FFCRA. So just to give you some background, Dina and Lisa covered this in the initial part of the presentation, but remember that the expanded FMLA applies to all employers from 1 to 49 employees and 50 to 500. The enforceability of it, though, is different. So for employers, for the bigger employers, the Department of Labor enforces the action, and there is also a private right of action for the employees. For the smaller employers, the Department of Labor is the only agency that is able to enforce any violations of the Expanded Family Leave Act. And just remember that traditionally, FMLA does not apply to employers with less than 50 employees, but that's an exception under the new amendments. And for you to be mindful of any violation of these new laws, there's damages that are available. So some of the damages are back pay, front pay, liquidated damages equal to the amount of back pay plus front pay, emotional distress damages, and punitive damages. And this is determined based on a case-by-case basis. The next point for you to consider is enforcement of the Emergency Paid Sick Leave Act. And all covered employers are subject to enforcement by the Department of Labor, and as well, employees have a private right cause of action. The enforcement are under the mechanisms of the FLSA, and the damages also include the amounts of unpaid wages, the equal amounts of liquidated damages, as well as attorney's fees. Now, these claims are typically brought as collective actions. So it's similar to class actions, but prospective plaintiffs must opt in. Now, one of the examples with respect to an enforcement action by the Department of Labor happened early on with the pandemic on April 23rd, 2020, where the Department of Labor conducted an investigation. And after an investigation of an employer, Bear Creek Electrical of Tucson, Arizona, they found that there was a violation of the Emergency Paid Sick Leave Act, and they required the employer to pay the employee $1,600 for refusing to provide leave when the employee's doctor instructed him to self-quarantine. So that's an example of an enforcement action. Now, Jillian, the next slide, please. So as Jillian mentioned earlier in the presentation, there have been about 800 cases that have been filed since the inception of the pandemic. So we wanted to give you some examples of what this means or what this looks like under the FFCRA. So, and Ruth mentioned some of this as well in a different context, but there's going to be tons of litigation we anticipate with respect to retaliation claims for working from home. And this example that we want to share with you is someone who filed a claim in federal court in Tennessee, and it was for retaliation for working from home and not having summer childcare. So in this specific circumstance, the plaintiff was allowed to work from home since schools were canceled in March. But when there was a transition in the summer that there were no childcare options, she requested leave under the various laws, the FFCRA, the EPSLA, and the Expanded Family Leave Act, because she had no summer care options. The employer failed to respond to her request, and rather than responding, they terminated her. So she filed a lawsuit under the various different laws, claiming that there were interference with her rights, there was a retaliatory discharge, also claiming there was a minimum wage violation, there was also retaliation under the FLSA, there was a breach of contract, as well as promissory estoppel. So we imagine and we foresee that there are going to be a lot more claims dealing with retaliation for working from home. The next example that we want to share with you is wrongful termination or violation of FMLA. So in this particular case, plaintiff advised her employer that as a result of the COVID-19 pandemic, she anticipated having childcare issues and would likely need to apply for FMLA leave. She took a vacation day, and while on vacation, her supervisor texted her and asked if she planned on taking FMLA leave. The plaintiff did not respond to the text message, but returned to work the following day. And then she was terminated the next day. So the plaintiff claims in this particular case that the person who terminated her told her that it was better for her to collect unemployment rather than to take FMLA leave. And so she brought a claim seeking wrongful termination, violation of the FMLA, and a request for equitable relief. And this was filed in New Jersey. So New Jersey seems to be taking the prize as to all the lawsuits that we're highlighting here today. But it's important for employers to understand that even if you think that collecting unemployment is a win for the plaintiffs or for your employees, you should not share that information. The reality is that employees are going to argue that they prefer to be employed rather than unemployed because unemployment is only for a certain time period. So be careful when making those comments to employees about termination. Now, I just want to briefly address the WARN Act. So generally, employers must provide employees with 60 days notice before a triggering event. And that's implicated because it covers mass layoffs and workforce reductions, which is what we're seeing with the pandemic. It applies to employers with 100 plus employees, and the penalties or claims for violating the WARN Act include a private right cause of action, wages and other benefits to the employee, what they would have earned during the notice period, and a civil penalty of up to $500 for each day the employer violated the notice requirements. The next slide. Please be mindful that we have the federal statute, but there's also many WARN state statutes that you have to be cognizant of. And some have been modified with COVID-19 related exceptions. So make sure that you check state law when you're making any major decisions about laying off a group of employees. There's an exception to the violation, which is an unforeseeable business circumstance. I'm sorry, an exception to the notice requirement. And really what that is it applies to plant closings and mass layoffs caused by business circumstances that were not reasonably foreseeable at the time that the 60-day notice would have been required. So the circumstances caused by some sudden, dramatic, and unexpected action or condition outside the employer's control. So what you have to be mindful is that this is a potentially good defense at the beginning of the pandemic, right? Where no one could have foreseen that we were going to be working from home for 8 months in March and April. But now that we've been in this for a longer time period, it's going to be hard to assert this defense if there is a lawsuit filed against an employer because it's no longer an unforeseeable business circumstance, right? So those are some of the considerations that you have to look into when making these decisions. Jillian, the next slide. Now, there have been, we have found 2 recent litigations regarding the WARN Act, one in Florida and one that was filed in federal court, the Southern District of New York. And they're essentially similar cases in that there are class actions under the WARN Act for failure to timely provide proper written notice after being subjected to a mass layoff or plant closing due to COVID-19. So, in summary, obviously it's important for you to look at the individual circumstances of the company, but please be mindful of the potential litigation that can ensue with the WARN Act as well as the FFCRA. Thank you. So I'll hand it over to Dina or Gary.
Great, thank you. So ladies and gentlemen, that concludes our formal presentations this morning. I want to take this opportunity to thank, our dream team of Dina and Lisa and Lauren and Jillian, Ruth and Anna Maria for a wonderful presentation today, substantively, that dove deeply with a lot of successful outcomes for you and good tips and points for how you can avoid that bad litigation world. And we got some really good tips going on there. So let me tell you what we're going to do right now. We're going to take about a 10-minute break. We do hope that you will stay with us and come back. And at 12:15, you will get an invitation to be put into a chat room, which will be your WISE forum. And it'll be a group of people everybody's an employer that attended today. And it's an opportunity to have a more informal session with Saul Ewing lawyers And by the way, how often do you get 45 minutes of free legal advice? Even though, remember that legal disclaimer I gave you at the beginning, but you get an opportunity to spend time with colleagues of mine and our firm in talking about issues of real importance to you today. So we ask you to come back at around 12:15 or so. I will just give you one reminder, because that's going to be a whole different seminar, is while you're away, please keep your camera muted, your camera off, and your voice muted, because we don't want to have another seminar about what you're not supposed to do on Zoom. So we'll see you in about 15 minutes or so. Grab something to eat and come back and see us. Thanks, everybody.
I can just jump in. Remember, the session for the breakouts really has to do with the challenge that you face every day. One thing is, we don't need you to focus on anything we covered today. You know, it really can be any challenge you're facing with your employees. We have some topics that we will throw out there if you're coming in and we need some jump starting, but really anything that you face this year with your employees. But one challenge, if you could think about it, if you haven't already, over the next 10 minutes, and we'd really like you to get a good discussion going with your peers that are in this meeting so that we can have a lively and active 40 minutes with the group. So thank you, and we'll see you all in a few minutes.